Welcome to our channel, episode 2, Wills and Trusts. Everybody's gonna die someday, so this is very important. Now grab a pencil and turn off your TikTok and listen carefully. Do not forget to subscribe us and give us a thumbs up. Love you guys. Okay, now we're in conference with attorney Mark MacCarley, partner in general counsel of MacCarley Rosen law firm.
Coming back, I thought I might have scared you off the last time we had our conversation about a week or so ago, and that time, it's kind of hard. Can you hear me through this mask?
I can hear you with the mask, yes.
All right.
Yes.
Miss Documentary filmmaker, are you able to hear us clearly, or do you recommend we just sort of lower the masks now?
I think you guys are okay, and you guys.
All right, I'm going to lower the mask. If you're
Okay.
willing, might be
Yes.
slight risk, but we have maybe, this looks like about 3 feet, not quite consistent with CDC guidelines, but we'll try to get through it. I'll just move this over.
Okay.
We always have to accommodate the current crisis and come up with some solution. But I know you came here, you had a couple of other questions.
Yes,
so I'm
yes.
ready if you are.
Well, I wanted to build off of the conversation last week to go from cash flow to dealing with preparing for, a crisis situation. There's a situation where there's a lot of loss of life, and right now I know a lot of people would be curious to know how to protect their property, how to protect their beneficiaries, so forth and so on. So I wanted to ask, in a situation, if someone were to pass away from COVID but not have a will, what type of situation would that put them in?
I appreciate the question. It's not a difficult question. On the other hand, it delves into matters that are very sad, meaning loss of life, and as you've stipulated or sort of suggested, loss of life as a result of COVID. Now, not touching upon such things as whether or not there are some death benefits associated with that person departing, to include insurance policies, whether term insurance policies with their employer, the minimal Social Security death benefit, which is $255, somewhere around that, and any pension benefits that might be paid when somebody passes on. What you have is this whole area, which we call in this firm, especially when we work with business people, is estate planning. And estate planning, what instantly comes to mind is a will. A will is a document, and there are certain requirements that must be complied with for each person or a person to prepare a will. What a will says is, firstly, these are my properties, at least to some degree of what we call specificity, meaning you can identify real property, that's probably good enough, and personal property. And that's the first thing, is identification of property. And the second is the intention of the person who has prepared the will. We call that person the testator, fancy word, basically meaning the person who is writing this particular document, which controls what happens to their property once they pass away. And that's the will. And so the second part of the will is really the intent of that person who's passed away, the expectation and the direction, really. Direction is a right word. Direction as to how his or her properties will be distributed. And as you know, that can either be a smooth process, or if somebody dies, and many people do, without a will, then it's often complete confusion. Complete confusion sometimes results in real controversy among what we call the heirs of the person who passed away. Heirs meaning the surviving spouse, wife, husband, as the case may be, children, and then if there are no children, a spouse, either parents or brothers and sisters, all vying to be identified as that person who receives a portion or the bulk of the estate. And that's a will. And so almost everybody instantaneously, when you say a will, has some idea of a will. As I said, there are a couple of requirements, and that is that all wills have to be in writing. There is one minor exception under some period of military duress, but that exception is so limited that requirements are put in writing, and then there is the requirement that varies, that is to have your signature to that document authenticated. And that's why you've heard that there have to be witnesses. In California, it's 2 witnesses. Some other states require 3 witnesses who have no relationship, are not the beneficiaries, are not receiving anything under the provisions of the trust, and they sign, and these individuals, these witnesses, verify that you are in fact, this is your signature as you have signed the will in front of them. Now, once again, like a lot of things in law, there are exceptions to that, and you might have heard what we call a holographic will. It's a sort of a term, and what that is a document prepared by an individual who's intent upon, 1, identifying his properties or her properties, and number 2, identifying to whom those properties will be transferred at the time of the testator. That's the person who writes the will, testator's death. The difference between the first will that we talked about, which was entirely written and witnessed by 2 or 3 witnesses, is that a holographic will has no witnesses. The requirement is that it be drafted in somebody's own hand. There's some real technical requirements which we don't need to go into, but frankly, that person who's writing a holographic will has to write it out, has to sign, own signature, and date it. And there shouldn't be any printed material. It really should be one person's statement in her own writing. This is my property, and this is to whom I want my property to go, signed by that person, and again dated. It's a holographic will. And holographic wills are recognized in this state. I guess you can almost speculate that sometimes holographic wills create a little bit of controversy or potential lawsuits, because it gets down to how we authenticate somebody's signature, and then you get into, was that indeed that person's signature, versus if you have a couple of witnesses and the witnesses are still alive as to the first more formal will, you can contact that witness and say, do you remember that that person, we show you a copy of the will, did in fact sign in front of you, and hopefully they will be able to say under oath, yes. So that's a will. What we strongly recommend is the use of a trust. A trust is a legal device in which you vest your property in this trust. The trust itself is what we sometimes call a much more complicated will, but in this instance, a trust is, in many instances, especially when it becomes what we call irrevocable, is a legal entity all by itself. So you have the trustor, that's the person who wants to identify whom will receive his or her properties, that's the trustor, and who puts the property in the trust. So if it were you, and you own, as you told me 2 weeks ago when we had the conversation about measures, cash flow measures
for
equipment
and
your
things of that nature.
lightheaded production company, you would put your membership certificates, since yours is an LLC, limited liability company under California law, and you put that membership certificate, and you put that certificate into the living trust. Now you'd also, you have to absolutely be careful about this. I see this because so many people make errors. You will, in writing, convey that membership certificate to the trust, and for that piece of property that you showed me where you do your production, that I call it, it's a studio. Other people. That property, which is in your name, has got to go to the trust. So while you hold that in your name, Mr. Waters, what you have to do is actually draft a deed and transfer your individual ownership of your studio, the real estate and the building, and transfer that into your living trust. What usually happens, a trust is sort of exists in the background, and it has really big benefits. One, it provides a sense of organization. A lot of people put almost all their assets of things that they own, real estate like you have, your business, lightheaded production studios, and put all those in the trust. They might keep a couple things out of it, maybe a little bit of cash, but put everything in the trust because it provides organization, clearly identifies who's going to get the property at the time of death, and most importantly, it could save literally thousands and thousands of dollars your heirs would incur, or devisees, people who get properties through a will, because a will, by its very nature, requires that when you pass away, there's a formal court proceeding, with some exceptions based upon instances in which the estate is under $166,000, a relatively small estate you can get by with just a simple piece of paper and not a lot of money. But for most people, if there's a will and you die with a will and you have a piece of real estate, oh my gosh, you're literally going to be paying thousands of dollars both to your lawyer and to the person that you designate as your executor or executrix in your will. So what's a trust do? Well, a trust eliminates all that. You have a trustee. You won't be the trustee when you pass away unless there's a miracle you've resurrected for the purpose of running your own trust. But somebody will become the successor trustee. So you might put your son, when you have kids, or put a trusted relative, sometimes your accountant, sometimes your lawyer as a trustee, and then when you pass on, that person collects all your assets, organizes, pays your debts, pays the taxes, and then distributes it without the necessity of court proceeding. So just to give you a finite idea, if you say that in California, on the average, the cost of a probate, let's say a probate in excess of $500,000 is about 2.5% of the assets that go through the court, the probatable assets. That's a lot of money.
Right.
That's a tremendous amount of money. Whereas you can probably, with a trust, eliminate that 2.5%, and which is about $30,000 or so. You basically only pay for the cost of that trustee, and sometimes if it's a family member, the trustee won't charge a thing. So it gives you, as a business person, sort of it's another tool that allows you, but we always say that those in the industry, your industry, have a creative streak. And so what's that relate to trust? It just merely means that if you have that type of organization in your trust, and we've worked through your business and cleaned up, let's say, the articles of organization in your LLC, and provided, let's say, at least monthly sort of minutes of the meeting of the managers, you have a sense of assurance that from an administrative perspective, and with a good accountant, of course, to keep your books and records on the up and up, that part of the business you don't have to worry about. And you can focus, and this is probably a good way of stopping, you can really focus your efforts as somebody who is at the creative front line in making those documentaries for which you are so well known. And so these little things are not the most important thing until they become the most important thing. So when you pass away, that trust or the will, as the case may be, there's nothing more important to your children or to your relatives, and in fact, to your business partners. At some point, you might bring a partner, meaning either a partner or another member of your limited liability company, and then yes, that person will be very interested in how you set up your estate plan. Mr. Wetters, I hope you appreciated I appreciated certainly our time together. This is the second, and I hope a fruitful business relationship that will arise. We'd be honored to represent your firm. But once again, I hope that I laid out for you the relationship between the ownership of management of Lightheaded, which is your limited liability company. Yeah. That's where you make your bread and butter by producing documentaries, and how that plays in or is integrated with your estate planning.
Yes.
Nobody cares about it when you're young. I know you're a good number of years younger than I am. I'm a little closer to the grave than you are right now. And so I think I focus more on estate planning than you would. But, you know, in today's hard driving circumstances with the pandemic as an ever-present threat and the potential for mortality, loss of life, pretty high. So I think all of us should focus on it. So you can see that there's a benefit. I'm glad you started opening up on these questions. I wasn't quite prepared for the fact that you went a leap from limited liability companies and staving off cash flow problems to estate planning, but it is the right sort of elevation of all the issues related to management administration of a company
Yes.
over the long term.
Thank you.
Thank you.